I mean, I guess there's overlap on counts 1 and 2 for these two defendants, but those are the only counts that overlap, right? Yes.
Yeah, I believe that's
Okay.
right.
All right.
Do you have any further questions for me, Your Honor?
No, not right now. Thank you, Mr.
All right, thank you, Your Honor. I'd be happy to answer any other questions you have.
Appreciate it.
Good morning, Your Honor.
Morning.
Okay. So I have arguments regarding several different counts in this indictment, as well as some of the overt acts, which I believe also need to be addressed, the alleged overt acts. And there's different arguments for different counts and alleged overt acts. I'm going to start with dealing with the this argument applies to the RICO count.
Can I ask you something
Yep.
before you get
Yes.
started that might assist me? I think Mr. Weinstein said you might have a chart. Do you have something that's shareable with the court, or
I
is it-
don't. I don't. A chart is overstating what it is.
Okay.
We went through. We were trying to determine what specific counts, what
Okay.
evidence has been provided to the jurors so far in this trial.
Okay.
So let me just give a little background. I'm going to ask the court to consider Ruan v. United States, RUAN v. United States, 142 Supreme Court 2370 to 2022 case. That case explained that the commonly understood rule that as a general matter, our criminal law seeks to punish vicious will. Consequently, when courts interpret criminal statutes, courts start with a longstanding presumption traceable to common law that the legislature intended to require the criminally accused possess a culpable mind state. Applying the presumption of scienter, courts have been legally mandated to graft the material elements of mens rea into criminal statutes that are silent on the required mind state. Okay, and to bring it to this situation, the RICO statute is silent as to mens rea for the accused, as is, well, and not so much mens rea. Well, it is mens rea, but there's also an aspect of this that will apply to the gang statute as well. In United States v. Resendez-Ponce, 549 U.S. 102, it's 2007 case, the United States Supreme Court wrote that the elementary legal principle is that every count of an indictment must set forth all material elements of the crime charged in order to be valid. In Division 2B of Elonis, E-L-O-N-I-S v. United States, 575 U.S. 723, it's 2015 case, our highest court again taught that the fact that if a statute does not specify any required mental state, it does not mean that none exists. The Elonis court explained that courts have repeatedly held that the mere omission from a criminal statute of any mental or criminal intent should not be read as to dispense with this essential element. The rule of construction reflects the basic foundational principle that wrongdoing must be conscious to be criminal. In other words, just because there's no mens rea listed in the criminal statute does not make it a strict liability crime. Okay, going to the indictment in this case. Count 1, RICO. Mr. Stillwell and Mr. Kendrick, to be guilty of count 1, the jury under the law would have to find that Mr. Kendrick and or Mr. Stillwell joined the conspiracy knowingly and willingly.
Mhm.
The state, I'm going to ask Your Honor to consider the Cotman case, C-O-T-M-A-N v. State, 342 Georgia Appeals 569. It was a conspiracy to commit RICO
Mhm.
case. That indictment alleged knowingly and willingly. My understanding, I have not seen the indictment, but I've been told the Trump indictment also includes knowingly and willingly. In this case, the state has not alleged, and the grand jury did not return a indictment, a true bill, alleging knowingly and willingly.
This Mr. Steele Mr. Steele argued this same argument before Judge Glanville pre-trial, before even jury selection began. And if I remember correctly, Judge Glanville actually ruled against it, this very argument. But it's a new judge, and I understand why they repeat it. So this is this shows me that Mr. Steele is still in the background somewhere, trying to help, because what Mr. Schardt is I believe is a good argument. Problem is, we're in Georgia, in Fulton County, and it should be approved because it's another one of these incompetent oversights from both the prosecution and from the grand jury. They missed out on a crucial element. But here, we're in Georgia.
The indictment for count 1 is missing an essential element that has been required by the case law. Although OCGA 1614.4 fails to include knowingly and willful mens rea requirement as discussed above, when the statute is silent on mens rea, courts define the proper mens rea requirement to avoid it becoming a strict liability crime. I will point the case to Wetzel, I think it's Weitzel, v. State 298 Georgia 20, that discusses the concept of just putting unlawful. Does unlawful, as the state did here, does that cover knowingly and willingly? Is that an effective substitute? Our position is it is not. We believe that the Weitzel case supports that. So, Your Honor, we believe that the RICO count 1 is missing an essential element that has not been required by statute, but is required by the case law. And because that knowingly and willfully requirement, that mens rea requirement is missing from the indictment, count 1 is subject to a directed verdict, a general demurrer and directed verdict, as it applies to both Mr. Stillwell and Mr. Kendrick. Now, turning to the gang counts, and I can get you the specific counts when I have a moment to look at the indictment. But going to the gang counts, the requirement, again, the gang statute under the Georgia Code is absent as to an essential element of the crime, which is in furtherance of the gang. That statute was in constitutional jeopardy before the Rodriguez case. The Rodriguez case saved the statute by adding an essential element to the gang statute, which is not only someone associated with the gang committing one of the specified crimes under the Gang Act, and the existence of a gang of 3 or more people. But additionally, Your Honor, they added, to save the statute constitutionally, the Rodriguez court added the requirement that the alleged illegal act must be in furtherance of the gang. The indictment in this case for all of the Gang Act violations, all the alleged Gang Act violations, none of those alleged Gang Act violations on this indictment returned by the grand jury allege that the act committed was in furtherance of the gang. Now, we know that that must be proven. The jury charges that we're going to give the jury list in furtherance of the gang as an essential element of this crime. And it is absent in all of the Gang Act violations alleged in this indictment, as the indictment for those counts does not allege every essential element of the crime. Those counts are subject to a general demurrer and a directed verdict as well. So that's one aspect of my arguments. I can move on to my other arguments, or I can put a pin in it.
Just a second.
Thank you, Denise, for $5 super chat, saying thanks for the recap. You're very welcome. You're very welcome. For SM1, finally catch you live. Yay! Yeah, thank you so much. Yeah, this is I'm not saying it is identical to Mr. Steele's argument before Judge Glanville, but it's close enough to me to understand that this material was handed to Mr. Schardt from Mr. Steele. And it should have worked, but we're in Georgia. Contact your local politician and tell them the RICO, the Georgia RICO, needs to be revised, overhauled, because this is ridiculous. We can't spend $15-20 million each time some underachieving district attorney wants to make politics.
And Mr. Abate just gave me, just helped me out, and I appreciate that, Mr. Abate. I'm referring to count 57 for Mr.
50,
Kendrick, and
51,
50 and 51.
57.
Yeah.
Thank you. Okay, go ahead.
So moving on to the overt acts, and I adopt Mr. Weinstein's arguments regarding count 2 as well. Moving on to the alleged overt acts.
Can you actually, I mean, you can adopt those, but do you have anything to add with regard to count 2? Because Mr. Weinstein was basically talking about, you know, the evidence or lack of evidence as to his client specifically.
The only evidence against Mr. Stillwell, there's no cell phone evidence.
First of all, thank you to Deja Vu, gifting 5 memberships. Thank you so much. Everybody say thank you to Deja Vu, bringing our new members of today to 5. And it was gifted to Shine Eyes, Kimberly Bono, Infinity, Emma Louise, and Mariana Mars. Heyo! You now have access to all the members-only perks on my channel. Yay! Thank you so much, Deja Vu. And now, Mr. Schardt is about to go into the absolute lack of evidence.
With regard to count 2, because Mr. Weinstein was basically talking about, you know, the evidence or lack of evidence as to his client specifically.
The only evidence against Mr. Stillwell, there's no cell phone evidence. There's nothing of that nature. There's no identifications from the scene. The only evidence are social media posts and the testimony of, well, not the testimony, the out-of-court statements by 2 individuals, one being Quindaria Zachary, who completely disowned what he said, and back in the interviews when he was under the pressure of incarceration, under the pressure of prosecution. And we pointed out, hopefully effectively, that Mr. Zachary's story about this confession changed in material ways from when he told the story in 2015 to when he told the story in 2017. When this confession allegedly occurred changed, what was said allegedly changed, the circumstances changed. And then Mr. Copeland, I mean, you were here for that. He made out-of-court statements under the pressure of incarceration. He's openly admitted he would have said anything to get out of jail, to avoid prosecution, to avoid Rice Street. And his statements were not even that he witnessed anything, but he was told something by someone else who did not testify. So that is as far as I can tell, the entire university evidence against Mr. Stillwell. And our argument is that it doesn't clear that hurdle of surviving directed verdict.
All right.
So moving on to the alleged overt acts. And I'll point out in this indictment, it lists, this is a conspiracy to commit RICO. So they don't need to prove the predicate acts. Those 2 related events within 4 years, they don't need to prove that, because all they need to prove is a conspiracy and 1 overt act. So
Well, a conspiracy to commit to interrelated racketeering acts in furtherance of the enterprise.
Yes. Okay. That is fair, but they don't have to prove that the
That they
acts
occurred.
actually occurred.
Agreed.
So on page 14 of their indictment, it starts part 3, acts in furtherance of the conspiracy. It says, in furtherance of the conspiracy and to effect its objectives and purposes, the defendants committed and caused to be committed, among others, the following overt acts, certain of which constitute acts of racketeering activity. So this part 3, this isn't about, they identify some things as overt acts. They identify everything as an overt act, but they also identify certain things as falling as a predicate under 1614.3 for racketeering activity.
Mhm.
The nature of this allegation is a conspiracy. So they don't have to prove that these predicates occurred. So essentially, my reading and my argument is that part 3 is essentially a list of overt acts. That's what it is.
Yeah.
And we are all of the same opinion. We're giving the jurors a jury instruction. It's clear, it's in the statute that the statute of limitations for the overt acts is 5 years before the date of indictment. And that's going to be, my understanding, that's going to be charged to the jury. So as a general principle, I do not understand if they only need one overt act, okay? And that overt act has to be within 5 years of the date of indictment. All of these other alleged overt acts that can't count, can't be used, and are completely not needed. I could see a situation, for instance, if they needed to show 2 overt acts, and one had to be within 5 years of the indictment, but one didn't, okay? It was just the last one needed to be within 5 years, but they needed to show 2. I could see the need for all of these other allegations, but that's not the case. They need to prove 1, according to their arguments, and it has to be within 5 years of the indictment. So everything that predates that cutoff date, which I think would be May 10th of 2017, it can't be used to
It's
convict.
not sufficient.
Well, but it doesn't add anything either because you only need 1.
Well, they
So
also have to prove a conspiracy and an enterprise. And so,
they do have to prove a conspiracy and enterprise, and I'm not arguing that they can't argue about these things in closing. I'm not, I never argued that they couldn't get into these things, but they shouldn't be alleged in the indictment going back to the jury because we're telling the jury, we're sending the jury a completely mixed message. We're saying you can't find an overt act that
we're not saying that. We're not saying you can't find an overt act before the 5 years. What I will be saying is it is necessary if you want to convict
right.
that.
Sadly, again, we are in Georgia and the Georgia RICO Act, which allows, beyond this 5-year span, between May 9th or something, 2022, back to May 10th, 2017, the 5-year span, they can still find the conspiracy further back than that through the overt acts, but they can't find they can't use it to they can't find an overt act outside of those 5 years to be unanimous on as, yes, we found them guilty on this overt act, because those overt acts does not count other than to show conspiracy. But within the 5-year span, which coincidentally, Donovan Thomas murder is not within those 5 years, but they still brought all of that crap in. And so the 5-year, luckily, the 5-year will make it a bit easier for the defense to argue against in closing arguments, I believe. But still, it's such a faster clock. Such a faster clock.
you find, or if you believe there is evidence sufficient to convict, part of that evidence has to be an overt act within 5 years.
But by definition, no, I'm not, believe me, I'm going to fight tooth and nail about any duty to convict language, and I don't think there is any. But in layman's terms, if they find something, if they find an overt act within 5 years, that is legally sufficient
Correct.
to authorize a conviction, which would make all of these other.
I hear what both of y'all are saying on that, and I just don't think I'm convinced that it should not even be presented to the jury because it's not sufficient in and of itself. But go ahead.
Okay, and
I mean, that's not exactly directed verdict issue anyway.
no, but I believe it is. I would say at this point,
Yes, you caught alive.
it is mere,
Surplusage.
yeah, mere surplusage, I would say, and that it's going to confuse the jury to have this list of alleged overt acts where legally none of these prior to May 10, 2017 can be used to authorize a conviction on the overt acts for the overt act element of the RICO conspiracy.
Mm.
So, and then additionally, Your Honor, in all candor, we stayed after court. We went through all the charged offenses in the indictment, all of the alleged overt acts in the indictment, and we did our best. We didn't have the evidence in front of us. We did our best over the night, over the evening and this morning to go through those, and we either said we're not challenging it. We recall that there was evidence that would survive a directed verdict.
Mhm.
We were unsure, or we're pretty certain there was no evidence of this.
Okay.
And so, but it's a long list, and probably I would suggest to Your Honor for that part of this argument, it kind of be more of a back and forth as opposed to me just listing off a bunch of numbers. I can.
Well, I've got to know what you're alleging.
Okay.
Are you talking about, like, help me out, which overt acts you think there is no evidence presented for?
Yes.
Okay.
What's that? Yeah, but
Have y'all talked to the state about this at all yet?
we haven't had an opportunity.
Does the state acknowledge that there are maybe at least some overt acts that no evidence was presented on?
Yes, Your Honor, and
Okay.
we don't intend to have that go back to the jury, and so we can discuss with defense
All right,
counsel.
I
those
can
acts.
certainly let y'all do that, and if there's some that, I mean, I know there were at least a few that no evidence got presented on, so to the extent y'all can reach agreement, that would be fine, and then if we want to take it up later in the afternoon after y'all have gotten a chance to get together on it, that'll work.
Okay, thank you. Your Honor.
And there may be some y'all want to argue about, so we can do that later, so that's fine.
Okay.
Okay, and then do you want to argue specifically as to the other counts against Mr. Stillwell?
Well-
We've done kind of 1 and 2 at this point.
Right. I've argued the gang counts.
Oh, right, and yeah,
And I've argued the RICO. The Shamal Drinks alleged murder. I
mhm.
think the video speaks for itself. I don't believe that there's sufficient evidence that would authorize a rational juror to come back with a guilty verdict. We heard from Dr. Stanley, the ME. She was clear. Mr. Abate asked if someone's foot could stay on the brake, and she acknowledged that a foot could come on the brake and stay on the brake after being shot in the neck. And I asked, what about lifting the foot off the brake and putting it back down? And she said that would be an impossibility. We see clear from the video that Mr. Stillwell was, I think, gone. I'd have to review my notes, but I'm going to say it was about 26 seconds, I believe, between when his car left and when that brake light on Mr. Drinks' car was going on and off. Additionally, we have the U-turn. Additionally, we have the negative gunshot residue test that we have no muzzle flash.
Mhm.
It seems to me that we would have a muzzle flash. If we don't have a muzzle flash, the logical conclusion would be the shot was fired from inside the car we have a negative gunshot residue result. And we heard from Mr. Coven from GBI. He followed all the procedures. Although there's been speculation and of course the grave suspicion jury instruction that we all go by, we're not supposed to speculate. We're not supposed to use conjecture, I think is the word that they use. And there's just a lot of speculation. Well, what if this happened? What if he cleaned the car? And there's no evidence that supports any of those theories. So the drinks murder, as well as the associated charges with the drinks murder, which would include a gun charge and also a gang charge, I believe, would also be subject to a directed verdict. As it applies to the final gun charge of Mr. Stillwell's on the 17th, I'm not going to argue that there's not evidence that could survive a directed verdict. You know, we've heard it was the gun that was found on Meadowlark was registered to Taisha Alexander. We've heard Taisha Alexander is Mr. Stillwell's girlfriend at the time. But I will adopt Mr. Weinstein's arguments. This was indicted as 16-11-133. We were put on notice for 133. It's missing an essential element. And we're going to argue that the state should not be able to alter on the eve of closing arguments, alter the charges. And also, I'm not even sure about the mechanics of how that would happen at this point. It's charged under a certain statute in the indictment. I guess
Well,
if
I
it were
think it would be just like we always do any kind of lesser included offense. I mean, that's their argument is, yeah, we may not have the elements, and they certainly don't have the elements for 133, but we have the elements for 131, and that's what should get charged instead.
Okay, well, Your Honor, every time that I've dealt with lesser included, it's because there's some sort of, maybe not surprise, but the evidence didn't come across quite as we were expecting or the state was hoping, or the defense requests a lesser included. We're not requesting a lesser included, first of all, but they put us on notice to defend against 133, and they left out an essential element, and now we're changing the charges on the eve of closing arguments. So that's my argument regarding that.